Welcome to the Ada K Show. I'm your host, Ada K, and I am a criminal justice major. I am also a deaf courtroom commentator, breaking down the gripping courtroom drama while providing full ASL interpretation, making justice accessible to everyone. Grab a cup of Java and let's dive in. Don't forget, comment, like, and subscribe. And if you love this channel, please become a member. Hello, everybody. I hope you were able to hop on over. We are now in a break for the Zachary Adams hearing that we were listening to. We will continue to watch that trial, but we are here for the Taylor Robinson hearing. And so hopefully y'all teleported over. I hope so. We were talking about weather real quick over my other feed. It has been bitterly cold. Even though it's 41 degrees, it feels like it's 22. The winds are brutally high. So yay. Hello, Jamie. Thank you for hopping in. Thank you for coming into this one. We are still waiting for court to start. I got a couple of things I want to announce. We are, like I said, we are waiting, patiently waiting. Let me refresh and make sure that we are not. Yep, we're still waiting. Okay, while we're still waiting, I got a couple of things I need to talk about. Camila Mendoza Olmos was last seen leaving her residence on the 11,000 block of Caspain Springs in San Antonio, Texas, just an hour away from me, at about 6:58 a.m. Wednesday, according to Bexar County Sheriff's Office. Camilla's mother stated that Camilla normally goes for a morning walk. However, she did become concerned when she did not return within a reasonable amount of time. Video footage from that time shows an unknown individual believing to be Camilla searching inside her vehicle for an unidentified item. Moments later, the footage ends. It is believed that she left the resident on foot as her vehicle remained at the location. The only items known to be on her person were her car keys and possibly a driver's license. Camila Mendoza, almost 19, was last seen outside her home in San Antonio on Christmas Eve, authorities said. I'm going to share this tab real quick. Let me get it up on screen. If you see this beautiful young woman, please contact the San Antonio Police Department or the Bexar County Sheriff's Office. She was, we'll just leave it here. She is declared missing. Again, if you see her, please. I know, so sad. It's been real hard for the families. She is 5 feet, 4 inches tall, weighed about 110 pounds. Last seen wearing a baby blue and black hoodie, baby blue pajama bottoms, white shoes, authorities added. The Bexar County Sheriff's Officer believes she was left the resident on foot and her vehicle remained at the location. So you guys, thank you so much for always being willing to keep an eye out, because you never know, they might be in your community, and I kid you not. People end up in the strangest places. June, thank you so much for bringing that to my attention. Also, for our fabulous mods, we have an emergency or breaking news. At least 3 people were found unalived because of an avalanche near the top of Spain's famous ski resort. At least 3 people have died following the avalanche near the top ski resort in northern Spain. A woman was also rushed to the hospital with hypothermia after the 8,850-foot high tragedy, which happened close to the Panacosta ski resort near Florida, near the French border. Alarms were raised about 1 p.m. this afternoon. Initial reports said that there were 2 fatalities, but it is now confirmed a third has died. Another 2 people have said to escaped unharmed. The first skier was found 45 minutes after the avalanche, and the second one 20 minutes later. Police said they did not believe any more skiers remained trapped. Regional government president George Azacon said he was shocked by the news about the tragic mountain accident, and he was canceling his my diary to head. He was canceling his diary or his calendars. That's what we call calendar. They call diary. To head to the scene. Earlier, the avalanche warning had been issued for off-pist pist areas where heavy snow had closed some runs in recent days. The ski center said on the website, snow reports showed depths of up to 100 centimeters or higher on the slopes of Formiguel, with a further 4 centimeter expected today. 3 people have been deceased, and 1 person is still in medical care. So the incident happened in the high mountain area. It's about 8,850 feet above sea level. They had heard about the tragic accident, which resulted in life. And our hearts and thoughts and prayers do go out to those families at this time. It was Angela who put the article about the missing person in the LifeCom. Thank you, Angela. Thank you. June was I couldn't remember. One did one did the other. Thank you so much, June, for the missing person in the San Antonio area. We are greatly appreciate that. I love my mods. They do a fabulous job putting into play for me information. Boy, it is rough. Oh my gosh. We are still waiting for the court mods. If you see, I'm on Court TV. I'm going to pull up Trial TV Live and see if they have anything. Why do they have the hearing and we don't? What? Okay, so there is a live feed. We are going. I guess Court TV is delayed.
Independent review of the written submissions, oral arguments, and applicable legal authorities, and to thoughtfully evaluate the matters presented. In doing so, the court has remained mindful of its duty to balance competing constitutional interests. Openness and transparency are foundational to our judicial system.
Hunt and David Ryman on behalf of the Deseret News, KSL, and other media interveners.
Good morning, Your Honor. Michael Judd on behalf of the Salt Lake Tribune and other media interveners.
Thank you, and good morning to you. Mr. Robinson, are you with us?
Yes, not behind me.
And Mr. Robinson, good morning to you as well. All right.
Not showing up on camera.
The court appreciates the patience of the parties while it considered issues raised by the media interveners. An appropriate classification of the transcript and audio recording from the October 24th hearing The court has taken the necessary time to conduct a careful, independent review of the written submissions, oral arguments, and applicable legal authorities, and to thoughtfully evaluate the matters presented. In doing so, the court has remained mindful of its duty to balance competing constitutional interests. Openness and transparency are foundational to our judicial system and essential to maintaining public confidence. At the same time, the public's right to access is qualified, not absolute, and may be limited when a legally sufficient justification exists. The court recognizes the substantial public interest in these proceedings and has approached its review with that interest firmly in mind. The court has independently reviewed the October 24th transcript and audio recording in its entirety in determining whether any restrictions on public access is warranted. The court considered whether such limitations are necessary to protect specific constitutional interests and whether less restrictive alternatives could adequately address those concerns. The carefully limited redactions ordered are narrowly tailored and designed to protect those interests while preserving the public's ability to understand the substance, context, and significance of the proceedings. By way of context, the transcript of the October 24th hearing consists of 83 pages, 80 of which contain verbatim record of the proceedings. Each page includes 25 lines of text, and the transcript reflects just over 2 hours of the courtroom proceedings. The duration of the hearings was 2 hours and 19 minutes. The closed hearing held on December 11th included detailed arguments from defense, prosecution, and counsel for the news media regarding what portions of the record should remain private and what should be made public. That hearing likewise lasted nearly 2 hours, during which time counsel addressed these issues carefully, line by line and word by word. The court acknowledges and appreciates the diligence, professionalism, and preparation demonstrated by all parties during both hearings. After full consideration of these arguments, the court determined that 246 words, approximately 1 page of the 80-page transcript, should be redacted. No other portions of the transcript were found to warrant restriction. The court further notes that the matters addressed during the October 24th hearing, including issues related to civilian clothing and shackling, are best understood when considered in their full context. The limited scope of the redactions reflect the court's effort to preserve that context to the greatest extent possible. The redacted transcript will be promptly filed on the docket by the end of today. The corresponding audio recording will require additional time to ensure that it precisely reflects the approved redactions and that no protected material is inadvertently disclosed. The court anticipates the audio recording will be available within approximately 2 weeks. This court notes the importance of the audio in addition to the transcript, because hearing what was said and how it was said is equally as important as just the transcript itself. The court's sole objective in this process has been to ensure a fair, orderly, and lawful proceeding that reflects the constitutional rights of the parties while honoring the public's qualified right of access. The court notes that the standing decorum order has also been updated and directs all parties to review the order in advance of future hearings. Accordingly, the court now issues the following order regarding the classification of the transcript and audio recording of the October 24th hearing. And turning to the order itself. The state of Utah and defendant Tyler James Robinson filed a motion to classify the transcript and audio of the sealed October 24th, 2025 hearing as private. Because the press requested notice of all such motions, the court held a closure hearing on December 11th, 2025 to address the classification of the transcript an audio recording of the October 24th, 2025 hearing. Prior to that closure hearing, the parties filed a joint status report identifying some 20 provisions of the transcript for redaction and stating that the balance of the transcript may be classified as public. Having reviewed the relevant pleadings from the parties and representatives of the press and heard oral arguments during the December 11th closure hearing, the court now rules and orders as follows. The public has a presumptive right to access court records. See Utah Rules Judicial Administration 202.02 sub 1.
See, even he has a problem with the word judicial.
That right, however, is not absolute. To support and achieve certain interests and objectives, a court may close portions or entire court records. A court may consider any relevant factor, interest, or policy, both in favor of and opposed to closure in determining whether to redact portions of or close all or part of a court record. In deciding whether to redact or close a court record, a court must balance the interests favoring opening and closing the record, and if it determines to close the record, determine there are no reasonable alternatives to closure. The parties have argued, and the court has considered, the following policy interests in determining the motion. 1, protecting safety interests. 2, protecting privacy interests and non-party participants. And 3, protecting the defendant's right to a fair trial. Approximately half the portions of the transcript the parties seek to redact address courtroom and courthouse security measures. Safety concerns are well recognized as justification for closure of court records. This undoubtedly includes references in the court record to specific safety measures undertaken as part of the court security plan and practices in highly publicized cases. This case generates extraordinary ongoing national and international attention, some of which is threatening in nature to the parties, their representatives, and non-party participants. The safety and well-being of all involved in this matter outweighs the interests of the public that are served by open court records. Nevertheless, and as the parties recognize, the court need not seal the entire transcript and audio of the October 24th, 2025 hearing to protect the safety interests of all those involved. Redacting selective portions of the transcript and the audio that reference security measures will serve safety interests while allowing for as much public access to the remainder of the record as possible. The court hereby orders the redaction of the portions of the transcript corresponding audio referencing security measures identified in the parties' joint status report and further pared down during the closure hearing. These include the following portions of the October 24th, 2025 hearing transcript. Page 4, line 19 through 22, following the word unshackling until the sentence begins with the word and. Page 4, line 25 until page 5, line 1, including the first sentence of the last paragraph. Page 5, line 9 through line 10, following the word proceeding and ending before the word but. Page 5, line 18 and 19, including the entirety of the bailiff's comment. Page 33, line 17 through 18, following the word courtroom until the end of the sentence. Page 34, lines 5 through 7, following the word arrested until the end of that sentence. Page 35, lines 24 through 25, including the last sentence of that page. Page 36, line 1, including the first word on the page until the sentence begins with the word that's. Page 40, line 12 through line 16, following the word outside until the word maybe. Page 41, line 17 through line 21, following the word on until the end of the paragraph. Page 43, line 11 through line 13, following the word jail and ending before the sentence begins with the word and. Page 55, lines 12 through 13, following the word people and ending before the sentence beginning with the word so. Page 64, line 18 through 19, following the word Ben until the end of that paragraph. And finally, page 70, lines 1 through 3, following the word clothing until the sentence begins with the word I'm. Protecting personal privacy is a recognizable justification for closure of a court record. To justify the closure of a court record, a privacy interest must be more than a desire to avoid annoyance, criticism, or embarrassment, and must serve to protect information of a highly personal nature. The parties initially identified 6 portions of the transcript to be redacted based off privacy interests. During the closure hearing, the parties withdrew defendants' requested numbers 1, 2, and 11. The remaining 3 requests were significantly pared down. The court has already ordered the redaction of request 3 for security reasons, including page 34, lines 5 through 7, as ordered above. The court also finds that privacy interests support this redaction. The court has considered the interests favoring closure of the remaining 2 requests for redaction and concludes that the information is not of a highly personal or sensitive nature. Privacy interests do not outweigh the public's interest in this case. Therefore, the court denies redactions of the following portions of the transcript: page 35, lines 16 through 17, and page 80, lines 22 through 25. The right to a fair trial seeks to ensure that the one accused of a crime will have his guilt or innocence determined solely on the basis of the evidence introduced at trial. Thus, if disclosure of information poses significant risk of endangering a defendant's right to a fair trial, then closing or sealing a court record to protect that information is justified. Nevertheless, when such information has already been introduced to the public arena, there is a suggestion that no additional damage can be done, and the issue of sealing or closing the record becomes moot. Here, the Joint Status Report identified 4 portions of the transcript for redaction, based on the argument that redaction is necessary to preserve defendant's right to a fair trial. The court is unconvinced that the disclosure of the selected portions jeopardizes that right. The information in question is contained in the charging instrument, whether directly or indirectly, as part of the factual allegations made against defendant and already part of the public arena. If this information poses a risk of violating defendant's right to a fair trial, defendant's first line of defense is found in the rules of evidence and criminal procedure. Closing or redacting these portions of the transcript in audio is outweighed by the interests and the objectives served by open court records and mooted by prior disclosures in the information. Therefore, the court denies the request to redact the following portions of the transcript in audio: page 55, lines 2 through 7, page 60, lines 24 and 25, page 61, lines 1 through 6, and 13 through 14, page 64, lines 11 through 17. These portions also refer to a potential non-party witness. The court has considered redaction to protect the non-party participant from risk of retaliatory physical or mental harm. However, the references made to that non-party participant during the October 24th, 2025 hearing offers the same but no additional information that can be found in the charging instrument and shared by law enforcement during a press conference. As a result, redacting those portions at this point is a moot issue. For the above reasons, the court orders the following. A transcript of the October 24th, 2025 hearing shall be redacted in accordance with this order and entered into the record. And the audio recording of the October 24th, 2025 hearing shall be unsealed for the purposes of the court clerk identifying the timestamps corresponding to the redacted portions of the transcript, which selected portions, once identified, shall be resealed. No copy of the unsealed audio shall be provided until the identified portions have been resealed. The court will sign this order today, and it will go into the record. Now, turning to the second issue. And the court now issues the following order regarding the media's request to intervene. Two groups of media outlets seek to intervene in this matter. Only the state and the defendant, however, are actual parties to a criminal action. The press need not be a party to a criminal action to pursue the public's presumptive right to access public court records. The press has already been provided with a mechanism through Rule 4-202.04 to protect that right.
By the way, we do have that. We will go through I will give you a run through. I'm not going to read every word, but we will get a run through of it.
And has already utilized it in this matter. For this reason, the court denies both requests to intervene. The court now reiterates and clarifies its order requiring parties to serve all closure or reclassification motions on the media dated November 10th, 2025, as follows. Again, the parties are ordered to serve all closure motions on members of the press who have requested notice. The parties must file proof of service with the court. A closure motion is any motion to classify or reclassify a presumptively public court record under Rule 4-202.02 as any other classification. The parties need not serve notice on members of the press court records that are presumptively not public. A court record means a record that is prepared, owned, received, or retained by this court. This includes hearings. Therefore, the parties are ordered to serve all motions to closure hearings on members of the press who have requested notice. The parties must likewise file proof of service with the court. Nonetheless, the parties are not required to serve notice on members of the press of motions to limit electronic media coverage. If members of the media intend to object to a closure motion and request a closure hearing, such objections and requests must be filed within 7 days of receiving notice. To promote judicial economy and to eliminate unnecessary hearings, the court may decline to hold a closure hearing if no hearing is requested. The foregoing should be treated by the parties as a standing order for the duration of this case. And that concludes the second order of this case. The court wishes all parties a peaceful holiday season and hopes that each of you is able, to the extent possible, to spend time with your loved ones. The next hearing is set for January 16th at 1 p.m. And Mr. Robinson, I will see you there at that time. Court is now in recess.
Oh, that was short. Okay. I'm adding a time to our calendar. I always do it in an hour to 2 hour slot. Let me save it. Okay. I'm going to get to that. Okay, we're going to talk about that real quick. I don't know what that is. It's too blurry. So I got to put my head around that and unwrap that a little bit. That was interesting. So give me a little bit of time to do that. I am going to bring us back to, should I go ahead, June, and create a part 2 for the Zachary Adams, Tennessee post-trial hearing part 2? I kind of feel like I should. So give me a minute. I'm going to create that because I don't feel it appropriate. Excuse me. I don't feel it's appropriate for me to run it under this when I've already. So give me a sec. I'm going to recreate the new post and put part 2. Create a new live stream. I'll teleport you. What did y'all think about those judges' orders? June? Angela? Anybody? I'm going to schedule it 11:45, 40. Yeah. That'll work. Now I've got to find the thumbnail. Dagnabbit. Give me a second. I got to find a thumbnail. I don't know where it actually stored. There it is. Okay, live stream created. Hello, Ari! We're going to be teleporting. We are going to be teleporting Boo. Once this finishes its thing. How you doing, Ari? Did you get my message in Discord? I don't like secret court stuff either, and I think this is being a little bit secretive and it doesn't make me happy. It does not make me happy. Okay, so I got to teleport us. Give me a second. Okay, so I can teleport now. So now I'm going to go live on the other one. Give me a minute. And then we'll teleport. Thank you guys so much for joining. But I'm not real comfortable with some of the secretiveness of this court, but I understand it. So they did only received a limiting party status is what they received, which is not what they initially wanted, in all honesty. They wanted more access, and in fact, they got more limited access, which to me is bullcrap. That is not how I think that should have gone, but that's my own humble opinion. Okay, I'm going live in the other one. Okay, guys, thank you so much for joining us. We're going to hop on over into the Zachary Adams hearing. It appears to be going on for a couple more hours. Please hop on over and join us over there. We'll dive more into what happened today there. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome